Minister Varani, you were a member of this very committee when on May the 30th, 2022, we ordered the production of the government's legal opinion. That motion passed unanimously. You were in support of that, Minister Varani. Now that you're in a position to do something about it, will you turn over the legal opinion?
The opinions and advice are matters of privilege, which you will appreciate as a fellow counsel, Mr. Brock. So those are, and I believe you've received a response both from the previous Deputy Minister, Mr. Daig, and also the current Deputy Minister who's sitting beside me to that effect.
I don't appreciate that, Minister Varani. What is the government hiding?
Mr. Brock, we can discuss the importance of solicitor-client privilege, but I'll put it in a pithy manner. It is an important principle that has existed for literally centuries in our joint profession that you and I both...
There's precedent. If I interrupt, this is my time. If I can interrupt.
Madam Chair, can I finish my response?
Precedent. Minister Varani, this is my time.
Point of order. Excuse me. It's very difficult for the interpreters to interpret when you talk over top of each other. So, Mr. Brock, I'll set you back to 45 seconds. Can you just shorten your question so we can get an answer in?
Mr. Varani, there is ample precedent of numerous governments, including this particular government, to have waived legal opinion, to have waived solicitor-client privilege. If the Prime Minister, to Justice Rouleau, was so serene and confident in his decision to invoke the Emergencies Act in light of Justice Mosley's repudiation of the invocation of that act, what is the government hiding?
Briefly, please, Mr. Brown.
I would say solicitor-client privilege is foundational to the development of legal advice in a candid and frank manner between a solicitor and their client. It is a sacrosanct privilege that has existed for centuries in British common law, and it is one that this government firmly believes in terms of producing.
And you, sir, have the position to waive that privilege.
We'll now move to begin for 4 minutes.
Thank you very much, Chair, and thank you, ministers and witnesses, for being here. You know, I've been here as well all this time. I've studied as much information as I can at this committee and outside of this committee on the invocation. I still believe more strongly today than I did in 2022 that the circumstances to invoke the act were not met, the threshold was not met, and in fact agree with Justice Mosley on his decision that it was in fact illegal and unconstitutional. That is a binding precedent, unlike Rouleau's particular ruling. Now, the other thing that I think the Canadian public need to understand is Canadians expect their government to follow the law, the rule of law, and not create an interpretation thereof that is convenient for the government to circumvent the existing law. And, you know, Mr. Varani, you had indicated that, you know, there are hundreds of years of precedent for lawyer-client privilege. And, you know, the relationship has lasted hundreds of years. And you know what else has lasted all that time? For Parliament to make laws of the land which govern the people. And by invoking the Emergencies Act, the Cabinet gave itself the power to pass criminal laws which Mosley found to be unconstitutional. Now, my question to you is, have you actually found and read the infamous broader interpretation? Yes or no? That the government relied on. Have you actually read the legal opinion, the broader interpretation that the government was telling everyone that they relied upon to invoke the Emergencies Act? Yes or no?
Mr. Motz, I'm trying to be helpful, but even answering that question would disclose solicitor-client privilege, which I cannot do here. But what I would say to you is that
let me stop you for a minute. You know, you obviously can you answer me the date stamp that was on that?
Mr. Motz, in terms of solicitor-client privilege,
okay, so you can't. The reason I asked that question,
the questions you're asking me,
yes or no, you've already answered. It was a yes or no.
Remember, excuse me?
Yeah.
Remember, we have interpretation. Please don't talk over.
It was a yes or no question.
Please don't talk over each other.
Mr. Varani, I don't believe for a second that the broader interpretation even existed when the Emergencies Act was invoked at the time of the invocation, for a number of reasons. And, you know, it wasn't really until the just weeks before the Reload Commission was about to begin, that we all of a sudden heard about this broader interpretation, that it somehow magically appeared. And it's really quite disturbing that this broader interpretation is there now, and no one's seen it. No one's heard it, apparently. Mosley didn't get an opportunity to have it as part of his disposal, and neither did Justice Rouleau, who indicated that the evidence that he found to support the government's invocation was weak at best, and that anybody else could have come to a completely different conclusion. He was disappointed the government withheld that. So one of the questions that I've had for a long time is, who actually is the client? And you're hiding behind solicitor-client privilege. And why is it so difficult to, is it the government? Is it of Canada? Is it the governor and council? Is it the prime minister? Is it the attorney general? In your opinion, who is the actual client in solicitor-client privilege in this particular case?
In this particular case, the client is the government of Canada, and what I would say to you is
Who is the people of Canada?
the same thing I said to Senator Carignan, which is that there's nothing to hide, but there's everything to protect. And what my job is to protect basic principles about the administration of justice. Solicitor-client privilege is fundamental to that system, as the Supreme Court has opined.
Well, we're just getting wound up.
I know.
Oui. Ma question s'adresse aux deux.
My question is for both ministers. Do you have anything to hide?
Plaisir de vous voir, sénateur.
It's a pleasure to see you, Senator. No, I don't. Then why don't you provide us with a legal opinion? Can I answer, Madam Chair? Because it is subject to solicitor-client privilege. Okay, fine. I'm a lawyer. I remember. I spent a lot of time studying privilege, but who's it in favor of? The cabinet, the client, the client. So why doesn't cabinet simply revoke that confidentiality? I think you two probably have a lot of power in cabinet. What are you waiting for to provide us with a legal opinion? Mr. Minister, you say Justice Rouleau decided this, decided that. He studied everything, but he did not study the legal opinion. It was refused to him. So there are two things. Either it's legal or it's unlawful. Forgive me, but every time the senator hits the table, it can harm the interpreter's hearing. My apologies. What are you waiting for? If the legal opinion is lawful, then share it with us, and we'll clear it up immediately. Mr. Senator Carignan.
You would appreciate that it is not the contents that we're trying to protect. What is critical in protecting solicitor-client privilege is a relationship that existed, as I mentioned, for hundreds of years between solicitors and their clients, which promotes candor and free and full and fair advice. Understanding that privilege is sacrosanct between that professional and their client. It is important to the functioning of law in this country and in British common law.
Don't talk to me that way. I feel like you are taking me for a fool.
Madam Chair?
Please do, and then Senator
J'en ai des clients.
So the point
J'en ai eu
is,
des clients. Si le client
I guess I'm not able to finish,
si
Madam
le
Chair.
client me dit, vous pouvez parler,
Senator
donner
Carignan.
l'opinion juridique.
If a client tells me that they are breaking solicitor-client privilege, then it is broken.
I remember fondly your frequent references to Supreme Court case law at this committee, Monsieur Le Carignan. The Supreme Court in case law has actually attributed this, and I'm reading from a case called McClure, that this ensures vitality of full
I conclude
between those who need legal advice and those who are best able to provide it. The
Point of
resulting
order,
confidential
Madam Chair.
relationship between the solicitor and client is a necessary and essential condition of the effective administration of justice. That's the Cour suprême du Canada.
OK, donc vous la cachez.
I've got a point of order.
Madam Chair, maybe,
Those are your words,
maybe it's a function of people talking over each other, but I know that the interpreters are having a very difficult time translating the exchange. And when they have difficulty, we lose out. Those who
Couldn't
don't
agree with you
understand the
more.
French language, I would have loved to have fully understood what Senator Carignan was putting to this witness, but I wasn't able to.
Okay, so
Translation was not able to keep up.
I totally agree. May I ask all committee members and the witnesses to refrain from speaking over each other, allow the witness to answer, and then ask the question. If you need it shortened, you can indicate that. So, Senator Carignan, you have 1.5 minutes left.
Donc, j'en conclus que vous avez quelque chose.
So I can only conclude that you have something to hide.